Thank you.
Thank you, Your Honor.
Gracias.
Okay, turning to some Orange County interpreter matters. Clemente Santos Saloa.
Thank you, Judge.
Your Honor, are we all set in Osceola County? May I be excused?
You may be excused. Have a good rest of your Saturday. We're going to go to Orange County.
Thank you, Your Honor.
Okay, all right. Let's see.
Madam Clerk, I apologize. I had a lot of trouble hearing, Your Honor. I'm sorry.
Well, I am too. I'm with you.
Good morning, Your Honor. Carlos Morales, State Certified Spanish Court Interpreter, once again.
That was the last case.
Okay, and Mr. Morales has previously been sworn. Mr. Morales, I can hear you, but you're faint, so if you could eat that microphone.
Okay, thank you.
We'll get started.
I will do my best. Thank you. We're connected, Your Honor.
Very good. This is 21MM1428, State of Florida. Well, let me confirm. Sir, please tell me your name.
Clemente Santos Ulloa.
I will appoint the public defender to represent you in this matter. I find probable cause for battery domestic violence. I'm setting your bond at $1,000. You're to have no contact with Ms. Carolina Solis. You're not to return to 3816 Beachman Drive. You're not to possess or consume any alcoholic beverages. All right? Your next court date will be provided. Will be provided to you. Did you understand this?
Yes.
I'm sorry, I can't even see. Can we possibly, yeah.
I have a question, though.
Es que yo tengo 4 hijos que son míos y 2 de la señora Carolina. ¿Cómo hago para yo recoger mis hijos o cómo?
Well, the thing is, I have 4 kids that are, well, they're my kids, and 2 kids that are Mrs. Carolina. So how do I go about picking them up?
Okay, well, I can't answer that question for you. However, I believe Miss Carolina Solis is present. Can you please tell me your name, ma'am? Can we interpret?
Oh, okay. I'm sorry. I didn't know she needed an interpreter. ¿Cómo se llama usted, señora?
Carolina Solís.
Carolina Solís.
Ms. Solis, you're the alleged victim in this case, so you have the right to briefly be heard today.
Señora Solís, usted es la supuesta víctima en este caso, así que usted tiene el derecho a opinar brevemente.
Anything you want to say to the court about this matter?
¿Hay algo que quiera dejarle saber a este tribunal sobre este asunto?
Sí. Pues yo hice la llamada porque pues es la primera vez que él es agresivo. Entonces, pues varias personas me dijeron que cuando sean agresivos, pues llamar por primera vez a la policía. Pues no hay que pasar la primera vez nomás por nomás. Entonces, él tiene una enfermedad de diabetes y cuando empezó la diabetes empezó como que a tomar a ser como un poquito agresivo cuando se emborracha, cuando toma licor. Entonces, pues era agresivo, pero pues no me pegaba. Entonces, o sea, yo lo controlaba, pero anoche pues no lo pude controlar y pues sí me dio un golpe, pero pues no quiero que ¿cómo se llama? Desapartarlo de sus hijos, o sea...
Okay, un momento, que interpretar. I made the phone call because this was the first time that he acted that way. He has been aggressive, but some people had told me that when someone's aggressive, it's the first time, we'll just go ahead and call the cops. Just don't let it be to let it be. He suffers from diabetes, and when he started with the diabetes, he became a little aggressive whenever he would drink alcohol, whenever he would get drunk. So he had been aggressive, but he had not hit me. Last time was the first time that he hit me, and I was unable to control him. But even though he did hit me, it's not that I want him to be separated from his kids.
Miss Solis, you're there in a room enclosed. Would you mind taking your mask down for a moment?
Bueno, señora Solís, ya que usted está en ese cuartito, en este momento, ahí sola, encerrada, ¿le importaría quitarse la mascarilla, por favor?
Okay, all right, thank you.
Gracias.
Criminal history, PTR, any history?
Yes, mostly traffic. Mostly traffic cases,
Okay.
DUI. Expired license.
All right, I earlier announced all of the conditions without the input of Ms. Solis. Everything's going to remain as is, except I'll set bond at $500. And again, no contact, no return to 3816 Beachman Drive. When I say no contact, that means none whatsoever with Carolina Solis, not to possess or consume any alcoholic beverages. This is until further order of the court. You can talk to your lawyer about possibly getting a modification, but for now, you have to abide by those conditions. All right, you'll be receiving your next court date. Thank you. Thank you.
Your Honor, does Your Honor want the interpreter to mention those conditions for the benefit of the victim? It was
Yes.
interpreted into the headsets for the defendant. But,
Yes.
muy bien, entonces,
I want everything translated, everything. So she needs to come back in. I understand it was going through the headset, but that's a good observation, Mr. Morales. The victim's here. If you could repeat that, I appreciate it.
yes. Entonces, para el señor Santos Ulloa, lo que se ha decidido es que la multa será la fianza será de $500. Las condiciones son que le está prohibido tener contacto con la señora Carolina Solís. Y cuando digo prohibido el contacto, es prohibido el contacto en absoluto. Le está prohibido regresar a la dirección de la Beachman Drive. Y usted, el señor acusado, puede hablar con su abogado en cuanto a pedirle una modificación sobre estas condiciones, pero para mientras todo esto seguirá vigente hasta nuevo aviso. Y entonces puede hablar más con su abogado.
Disculpe.
Thank you.
I apologize.
Disculpe, es que tiene sus hijos y pues exactamente yo no fue los golpes graves, pero yo prefiero que regrese a la casa, pero o sea, es la primera vez que me ha agredido y pues o sea, mis hijos son 2 y los de él son 4. Entonces, prefiero que él regrese a la dirección, pero pues, o sea, yo levantar los cargos de que él tiene él.
Well, the thing is, he has his kids, and it wasn't really so much the blow. It's the first time that he is acted this way, and I would like for him to return to the house. It's the first time that he has battered me or harmed me, and I have 2 kids, but he has 4 kids. So I would like for him to return to the address, and I do not want to pursue charges.
Okay, thank you, ma'am. That does conclude this initial appearance hearing. The order stands.
Gracias por su
Thank you.
opinión, señora. Ya queda concluida esta vista. Gracias.
Next case I have here is Ruben Arancibia, but we'll need him to come in just a moment. Defendant's wearing the headset. Just want to confirm identity. Sir, please tell me your name.
Rubén Arancibia.
Mr. Arancibia, the court's reviewed the police report. I find probable cause for all listed charges. Public defender will be provisionally appointed to represent you. Your bond on count 1, burglary of a occupied conveyance, will remain $5,000. Count 2, aggravated assault with a weapon, the bond will be $2,500. Count 3, resisting without violence, will be $150. Count 4, criminal mischief, the bond will be $150. Count 5, battery on a law enforcement officer, the bond will be $500. Count 6, criminal mischief, the bond will be $100. Count 7, resisting an officer without violence, the bond will be $100. And count 8, battery, the bond will be $100. You're to have no contact whatsoever with the following individuals: Gonzalez Desayas, Ibran Desayas, and Leidy. Just a moment, can't read my handwriting. Leidy Marino. Those names may not be known to you, but those are the other individuals who were involved in the traffic matter, and you're to have no contact with them whatsoever, not to possess or consume any alcoholic beverages, and this will be supervised by pretrial release on any charges that are eligible. Next court date to be provided.
Your Honor, may the state also request no weapons as a condition of pretrial release?
That's reasonable. Not to possess any weapons or firearms, Mr. Reverencibia. Your next court date to be provided. Thank you.
And Your Honor, I'm sorry, the case number, please.
Yeah, those charges qualify. We were doing bond and, right? Bond and PTR?
No, he did bond plus PTR.
Yes, bond plus PTR, thank you. Okay, that does conclude the matter. Those are actually victims, yeah, and witnesses on scene who were quasi-victims. Yeah. All right, good afternoon. I'm Judge Epperson. Please tell me your name.
Jose Ramos.
Jose Ramos.
Jose Ramos Martinez.
Ramos Martinez.
Okay, that's why I ask. He's out of order. I will appoint the public defender in this matter. Having reviewed the police report, I find probable cause for 3 of the charges. First of all, I find probable cause for trafficking in heroin. Your bond will be $200,000. I find probable cause for count 2, possession of cocaine. Bond will be $150,000. I find no probable cause for the 3rd count of cocaine, and the defendant will be ROR'd. I find probable cause for the lesser included of attempted destruction of evidence in count 4, and the bond will be $150,000. And I find no probable cause for possession of heroin with intent to sell or deliver within 1,000 feet of a place of worship, and the defendant will be ROR'd on that charge. Your next court date will be provided, and the public defender again has been appointed to represent you.
Judge, if I could briefly be heard on in regards to release conditions, I think the $200,000 bond is beyond the financial means that my client would be able to post. If we could reduce it down to a more reasonable financial bond within his means, I have no other objection to release conditions.
All right. What is the basis of your awareness of his financial portfolio?
We previously represented him on other charges, and that bond amount has not been an amount that he's been able to post previously. And in full candor, that is the basis, right? Okay.
Well, the ability to pay is one of the factors to consider. That's reasonable. But given the totality of circumstances, that'll be the bond for now, and your lawyer can pursue a modification to that with the trial court, but that's going to be the bond for now. All right, thank you, sir.
Yeah. Your Honor, I'm sorry, can the interpreter get the case number, please?
Sorry about that, Mr. Morales. Case number 21, CF 2404. Yeah, you just add 77704, I believe. One moment.
No problem. Thank you.
Yeah, 777.04, you add to that, that's the attempt statute. Okay. All right, the next one I have is Alfredo Solarzo Arzate. Oh, he bonded, okay, all right. So I believe we've concluded the Osceola and Spanish interpreter cases. And I'd like to call the first case up, counsel's case first up when we resume. You already have it? Oh, great, thank you. Okay. So I do need to review it, and we'll, if we can manage to get Jeffrey Paredes out, he'll be next. Jeffrey Paredes.
Your Honor, I'm sorry, just for the interpreter's benefit, is this still an interpreter case? Or
No, Mr. Morales, I don't believe so. No, it's not. So thank you for your services. We'll go ahead and excuse our interpreter. Sorry to leave you hanging. All right, I'll end the call.
Thank you. Okay.
All right, are you Jeffrey Paredes?
Sam?
All right, good afternoon. I'm Judge Epperson. And counsel, if you could put your name on the record.
Yes, sir, Judge. Attorney Alexander J. Smith Johnson for Mr. Paredes.
All right, Mr. Johnson, did you want to be heard on these matters?
Judge, if I could, I would like to be heard on the felony case. I believe that's 2021 CF 000624.
Yes, sir.
And he also has a misdemeanor matter, Judge, 2021 MM 0000371, I believe, Judge.
Okay, I got the felony, and then I've got a citation for attaching tag, which is 21-1595, and then 21MM371. All right, and candidly, we pulled this out of the stack. I need to review the matter, but I can multitask if you wanted to be heard.
Judge, I mean, it's up to you. What I would say, Judge, please take your time. I mean, I am in no rush, and then when Your Honor is comfortable,
okay,
you can definitely do business.
Okay, before we get into it, PTR, do you have criminal history for the defendant, Jeffrey Paredes? Or do you need a moment, or?
He doesn't have any history, Your Honor.
No history? All right. Counselor, do you want to be heard?
Judge, as far as bond on the case ending in 624, I see that there's a no bond being on the third-degree fleeing. Judge, we would humbly ask the court to first consider any non-monetary release ROR, but if Your Honor is worried about Mr. Paredes' ability to subsequently appear at hearings and things of that nature, we would fashion to the court a proposal of a $1,500 bond on count one, the third-degree fleeing, and then if Your Honor would consider reducing the resisting an officer without violence first-degree misdemeanor from 500 to an ROR, we would have no problem with that. And then, Judge, in 2021 MM 000371, we were asking for non-monetary sanctions on those just to have him released. I believe those are two second-degree misdemeanors, allegations dealing with the endorsements on a motor vehicle and things of that nature. It doesn't appear to be anything violent that would give what I think the court any concerns about the public safety or, again, his ability to be present for subsequent proceedings.
All right, state wish to be heard at all?
No, Your Honor, nothing from the state.
All right,
Judge, the defendant qualifies for straight PTR.
okay. A court has already determined probable cause for fleeing and attempting to elude and resisting an officer without violence in case 20, it's the CF case, let's see.
I have 2021 CF 000624, Judge.
Correct, 21 CF 624. Notwithstanding that earlier finding, I went ahead and took the liberty of reviewing the affidavit so that I could fully appreciate the facts that led to the warrant being issued. Having done so, I'm setting bond at $2,500 on the fleeing and eluding, $500 on resisting an officer without violence on count 2. Turning to the traffic matters in 21 MM 371, on count 1, operating the motorcycle without endorsement, your bond will remain $250. I'll ROR the defendant on count 2, failure to register motor vehicle, probable cause on each. And then on the attaching tag in case 21 CT 1595, on that particular case, the bond will be $150. And your next court dates, actually, I'm also going to add as a condition of your release, you are not to be in actual physical control or possession of any motorcycles whatsoever. All right, and your next court dates will be provided.
That's one more case.
Oh, I missed a case.
1596. There's two traffic CC cases. It's on one affidavit, but it's two separate case numbers. Flip the page.
Okay. So we have another case, and that's 21 CT 1596, no motor vehicle registration. Go ahead and ROR the defendant on that particular case, notwithstanding probable cause, even though there's a finding of probable cause. And counsel, are you going to be representing the defendant moving forward?
Yes, Judge.
All right. All right, Mr. Paredes, you'll get your court dates. Thank you.
Thank you, Your Honor.
All right, folks, we're going to need to take a recess. I've got all of those other matters to review. It is now 12:20. My best effort is going to be for you to enjoy a lunch break while I'm reading, and we'll resume at 1:30 is my best hope. All right, 1:30, and hopefully we can get them done.
All right.
Oh, move-up cases, yes. Yes, 6 cases. We'll do those. We'll do those.
This is another private case you need to read, but it's not
Okay.
part of it.
And a warning to all, I'm going to read these as we go, so it might be a little slower than usual, but let's go ahead and bring in Mr. Christopher Novi. Are you Mr. Novi?
Yes, I am.
All right, I'm Judge Epperson. Give me a moment. I need to look at the police report. Okay, just a second. Okay. All right, Mr. Novi, you indicated you have a bank account. How much is in your bank account?
At this current moment, to my knowledge, $8.73.
That's pretty specific knowledge. Is this 2003 Toyota and 2006 motorcycle, are they paid off?
Yes, sir.
What would you estimate their total value?
The Celica, I would estimate about $5,000. The motorcycle, anywhere from $4,000 to $5,000.
You have no dependents?
No, sir.
It's close. I will appoint the public defender to represent you in this matter. So you now have legal counsel. I've reviewed the police report. I do find probable cause for 2 counts of battery, domestic violence, before determining bond or conditions of release. PTR, any history?
No history, Your Honor.
No history. All right, sir, your bond is going to be $500 on count 1, $250 on count 2. Should you make bond, you're to have no contact with Karen Novi, no contact with Jordan Novi. For now, you're not to return to 2827 Abney Avenue. Do you have personal belongings at that location, I assume?
Yes, sir, I do.
Oh, I'd grant a one-time return with the assistance of the sheriff's office for acquiring personal belongings such as clothing, toiletries, tools for trade. And that's until further order of the court. You can talk to your lawyer about getting a modification possibly, but for now, that's the order. Just one moment.
Your Honor, he does qualify for straight PTR.
Okay. All right, I'm going to maintain the bond as I've indicated. All right, thank you.
Thank you very much.
Michael LaCorn. All right, I'm Judge Epperson. Good morning. Your name? Your name?
LaCorn.
Michael LaCorn. All right, just a moment. We'll appoint the public defender to represent you in these matters. All right, a court's already determined probable cause for first-degree murder with a firearm and
second degree.
Just a moment. Correction. Second-degree murder with a firearm, which is a PBL, just means punishable by life as a maximum sentence, and also count 2, attempted first-degree murder with a firearm, which is also potentially punishable by life. Given those circumstances, for now, the defendant, counsel, you want to be heard?
Yeah, I would like to be heard. At this time, I haven't received any motion from the state seeking pretrial detention. That being said, the standard for holding someone no bond on a punishable by life charge is proof evident presumption great. I can provide the case law that's necessary. That being said, I don't think there's adequate evidence to show a finding of proof evident presumption great as of now.
Right, isn't there case law that says at initial appearance that determination doesn't have to be made?
I believe there's a split in the Fifth. I checked this a couple weeks ago. To be in full candor of the court, I believe there's a split as far as decisions go. So if Your Honor is not comfortable issuing a bond right now, I would just ask the entire Arthur meeting be preserved for the trial court within a reasonable time. That being said, I would still posit that I think a finding of proof evident presumption great still needs to be found. But if you were to disagree.
I agree with you. That does have to be found in order to justify a no bond. However, I don't believe it has to be determined at first appearance based upon the prevailing case law. So it will remain a no bond, and you would be entitled to a prompt Arthur hearing where the standard that you've just articulated would have to be established by the state. All right, but for now, that is the status. It's a no bond on both counts 1 and 2, and the next court date will be provided, in this case, 21 CF 2380. All right, Mr. LaCorn, you have legal counsel representing you, as you can tell. All right, thank you.
Thank you, Your Honor.
Rudolph Clear.
Here.
Okay, all right. Are you Mr. Clear?
Yes, I am.
All right, good afternoon. I'm Judge Epperson. One moment. Sir, you indicated you do have a bank account. How much is in your bank account?
Probably $1,200 all told.
$1,200?
Yes.
All right. Based on your application, I will appoint the public defender to represent you in this case.
Judge, if I could just have a moment, please, if you wouldn't mind. If I could please just have a moment to review.
Yes.
Yes, Judge, the defense will be comfortable waiving the reading of the charges.
All right, the court will waive the reading of the charges. There are 3 listed charges. And a court's already determined probable cause. I need one moment. Both counts 1 and 2 are designated as capital offenses, so the defendant will remain 0 bond on counts 1 and 2. Just one moment. As to count 3. Count 3 is a first-degree felony that is potentially punishable by life. The defendant will remain in 0 bond, and as we mentioned earlier, he would be entitled to an Arthur hearing. But for now, the bond will remain 0 on counts 1, 2, and 3. Public defender has been appointed, and your next court date will be provided. All right, thank you, sir. The next gentleman I'm expecting would be Mr. Narkeith Payne. All right, good morning. Are you Mr. Payne?
Yes, sir.
All right, I'm Judge Epperson. Just give me a moment. Okay. Yeah, I'm sure he does. But, sir, how much is in your bank account?
Right now, I have nothing in my bank account.
Couldn't hear you.
I have nothing in my bank account right now.
Public defender is appointed in this case. So, Mr. Payne, you have legal counsel here today for you, sitting there to your left. Just one moment.
Well, I actually been charged with something.
All right, from PTR, criminal history.
3 felonies, 5 misdemeanor convictions. Most of the convictions are on firearms or battery. Drug charges. Traffic. He wasn't interviewed, Your Honor, so
I didn't hear the last thing you said.
he was not interviewed for PTR.
Okay. All right, Mr. Payne, there's 6 listed charges today. I find probable cause for the first 4. Count 1, grand theft of a motor vehicle. Your bond is $1,000. On count 2, criminal mischief, greater than $1,000. Your bond will be $1,000. On count 3, grand theft, your bond will be $1,000. On count 4, grand theft of controlled substance, your bond will be $100. The court finds no PC for count 5, as it was not distinguishable to the court to the other property items in terms of an individual theft. So no PC count 5, ROR, no PC count 6, ROR. Your next court date will be provided, and the defendant should be subject to pretrial release supervision if qualifies. Okay? All right, you can talk to your lawyer. All right, thank you.
So that's bond plus pretrial release?
Yes, bond plus pretrial release qualifies, yeah.
Judge, you're quicker on the gun than I was.
How's that, in reading it?
Yes.
Oh, yeah. Well,
You said all the bonds.
that's all I've done for 30 years is read
They're all,
those.
the first 4 are 1,000, 5 and 6 are ROR.
ROR, right?
I'm- Mr. Francis?
Yeah.
Hello there. I'm Judge Epperson. How are you doing?
Well, I'm in jail.
Yeah?
Yeah.
Well, that's because you've been arrested and the court needs to review the police report. You've been arrested for trespass and possession of a controlled substance. One moment. Having reviewed the sworn affidavit, I find probable cause for each. Public defender wish to be heard at all on the matter?
No, Judge. Not, it's just so long as reasonable release conditions could be established.
My charges? Hey. What was my charges? I had 2 charges?
Yes, sir. Okay, so trespassing at the Wawas located on Colonial Drive,
Okay.
and then possession of a controlled substance called clonazepam. Those are the 2 charges. Count 1 is a misdemeanor, and count 2 is a felony. If you're released on the case today, are you going to come back to court?
Just keep me here and get it over with.
Well, Judge, we can still establish a bond then in this case. If then Mr. Francis would like to then, resolve his case while he's still incarcerated, that would then be his choice. I would just have to make sure we have a reasonable bond be set.
Okay, so the bond on count 1, the trespass, will be $100. Bond on count 2, possession of a controlled substance, will be $250. Next court date to be provided.
Thank you, Judge.
Thank you.
Where do I go now?
All right, sir, are you Jarvis Hardin?
Yes, sir.
All right, I'm Judge Epperson. Good morning. Just one moment. I need to read the report.
I think I have an offer. Yeah, usually that's all I do.
I'm going to make a provisional appointment of the Public Defender's Office today. So you have an attorney today. I do find probable cause for trespassing. Counsel want to be heard at all?
Yes, briefly. I think I was just briefly speaking with the state. I think this possibly could resolve today. I'd like to talk to Mr. Hardin and make sure the state has an offer before I firmly confirm that. But I think it's likely we can resolve this today.
I do, Your Honor.
Okay.
The offer to resolve this case, Your Honor, is an adjudication of guilt to the trespass property after warning, 810.095. Credit for time served, Your Honor. No return to the scene. Court costs, cost of prosecution, cost of defense, Your Honor.
Yeah.
Judge, I don't know if we have a plea form already signed or if we could provide a plea.
I'll do this one without a plea form if you're comfortable. Mr. Hardin, please raise your right hand to be sworn. Do you solemnly swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth? So help you God.
Yes, sir.
You can put your hand down. Now, you're charged with trespassing on property after a warning at the Citgo gas station on Colonial Drive. Your attorney has said you want to enter a plea of guilty today. Is that true?
Yes, sir.
Did you have a good chance to talk to him?
Yes, sir.
I need to hear you.
Yes, sir.
Do you understand you're giving up your right to a trial by entering this plea?
Yes, sir.
Are you right now under the influence of any drugs, alcohol, or medication?
No, sir.
Has anyone made any threats or promises to persuade you to plea?
No, sir.
If I accept this offer, this agreement between the parties, are you going to stay away from the Citgo gas station on Colonial?
Yes, sir.
You want to plead guilty to this charge?
Yes, sir.
I find an adequate factual basis based upon the sworn report to accept your plea of guilty. I accept your plea of guilty. Adjudicate you guilty. Just one moment. Sentenced to 2 days in the Orange County Jail with credit for the 2 days that you've already served. There are mandatory court costs of $273, $50 cost for the public defender, grand total $323. You must pay that within 120 days to the Orange County Clerk of Court. You have 30 days to appeal, and I'm ordering that you not return to the Citgo gas station at 4135 West Colonial Drive. Did you understand all of that?
Yes, sir.
All right, you're going to be released on this case today. Just make sure you don't go back there because there's a trespass warning. All right, thank you.
Thank you, Judge.
Thanks. Okay. The gentleman that you mentioned? Yes. And I think this was an interpreter case. I'm just going to put it on the record. I'm just going to put it on the record that this gentleman does not qualify, I think, for PTR. So I'm going to nullify that aspect of the judgment, or not the judgment, but the initial appearance order. So it will not be with PTR. Does not qualify. Anyone here speak Spanish? Okay, thank you. Here's the short message. The defendant will not be on pretrial release, but he does have the bonds as announced before.
Thank you.
Thank you, Deputy. All right, thank you, Officer. We're going to be, I think we can take a recess now, right? I've got a stack to read.
Yep.
So let's make it 1:45. We'll reconvene, and hopefully we'll be able to roll on through. All right, brief recess.
Thank you, Judge.
Okay, back on record. We'll resume with initial appearances. Just so you know, of the cases remaining, I'm going to go through about 80% of them, and then we're going to take about a 20-minute break, and I'll finish the rest. So we're going to start with a case involving private counsel, and we're going to see if we can get him on the line, I guess. And let's see, which case was that?
It's right here. I have that.
Okay.
And I'll take.
Here's the orders.
Thank you, and those go underneath those.
Yep. Okay. All right, this is Judge Epperson. We're reconvening for initial appearance. The case I have now is 21 CF 2362. State of Florida versus Darlene Romero. Are you Ms. Romero?
Darlene Romero.
Okay, we're getting your counsel on the phone.
Hello? Is there a button highlighted on the screen?
There's call, share, and messages. Counsel, can you hear? Teleconference? Counsel, can you hear me? Testing. Let's do it. Let's, yeah. That's, okay. We could just put the microphone there to the speaker.
You want me to put the phone to the?
I mean, whatever will amplify it, yeah. Yeah, that's good, thanks. Okay, counsel, can you hear me? You could please state your name. Why don't we put that microphone? My name is Jerry Gurley.
Attorney Jerry Gurley.
Okay, just one moment, Mr. Gurley. We're putting the microphone there where we can hear you. Okay, I've called up the case. This is Judge Epperson. I've called up the case of Darlene Romero, 21 CF 2362. Did you want to be heard, counselor?
No, Judge, I just wanted to make sure that she was being, that a bond was being set today for her. I know that was what the court was going to determine whether or not there was probable cause. Not making argument today, Judge.
Okay. There are 4 listed charges. I've reviewed the sworn affidavit, Ms. Romero, and I'm finding probable cause for the first 3 of these 4 charges. Count 1, possession of cocaine. I'm setting your bond in the amount of $2,000. On count 2, possession of a firearm by a convicted felon, your bond will remain $4,000. On count 3, possession of ammunition by a convicted felon, your bond will be set at $2,000. And on count 4, possession of a firearm in commission of a felony, I'm finding no PC. And that's because if you read the...
I'm curious, yes, Your Honor.
Well, if you read the statute for possession of a firearm in the commission of a felony, the firearm has to be in furtherance of the commission. The fact that a felony is committed and there might be a firearm in the vicinity, in the court's reading of that statute, doesn't mean it's in furtherance of the commission of the felony.
Thank you, Your Honor.
Yes, Judge, and I would agree. This is Attorney Gurley.
So that's those are the bonds that you have in the case. You're also, should you make bond, you're not to possess any controlled substances or any illegal substances unless you have a prescription for a controlled substance, and you're not to possess any weapons or firearms, of course. And your next court date will be provided. All right? Thank you.
No bond?
All right, thank you.
I gave you bond, yes.
Yeah.
All right, thank you, Mr. Gurley.
Thank you, Your Honor. Bye-bye.
Good day. Bye-bye.
Judge, she has another case. Did you set a bond for the DUI?
Oh, I'm sorry. Ms. Romero needs, that's my fault. Yeah. He's gone? Okay, that's fine. Yeah, count 4 is ROR. Ms. Romero, I made a mistake. I failed to put your driving under the influence charge on the record and deal with that, and your bond will be $500. And in addition, if you make bond, you're not to possess or consume any alcoholic beverages or go to any bars. All right, thank you. Okay. Dante Sylvester, I believe, is next. Good afternoon, sir. Your name?
Jeffrey Cross, sir.
Oh, Jeffrey Klein. Okay. Jeffrey Carr?
Yes, sir.
Are we in felony, Your Honor?
Yes.
Yep.
Case 21 CF 1898. Mr. Carr, I've reviewed the police report and I find probable cause for the battery allegation. Actually, it was already, probable cause determination was made by Judge Beamer, but I also reviewed that affidavit. This is 21 CF 1898. Criminal history?
5 felony convictions, 10 misdemeanors, 1 failure to appear.
Felony DV?
It's first in the docket.
Oh.
Setting bond at $2,000. Should you make bond, you're to have no contact with Katrina White. You're also not to possess or consume any alcoholic beverages or any controlled substances without a prescription. All right, thank you, sir. Your next court date will be provided. The public defender's office will be appointed.
I apologize, Your Honor. I had a paper mix-up. What did you set the bond at, Judge?
On Monday.
2,000, I believe. Yeah, 2,000.
Thank you, Your Honor.
Thank you.
Thank you, sir. Hello, sir. Your name? Mr. Pierre, I'm Judge Epperson. I've reviewed the police report. I do find probable cause for aggravated assault with a firearm, count 1, and battery in count 2. Public defender is appointed to represent you in this case, so you have legal counsel. History?
Only 1 misdemeanor conviction.
1 misdemeanor?
Mm-hmm. No felonies, no FTA.
All right. All right, Mr.
Qualifies for PTR.
All right, given the facts that the charge is predicated upon, you're presumed innocent, but given the allegation, I'm setting your bond at $2,500 on count 1.
Judge.
Oh. Are you Ms. Pierre?
Yes.
Well, Ms. Pierre, since you're the alleged victim, you have the right to be heard today. Is there something you wanted to say?
I'd like to drop all charges.
Okay. State or defense have any questions, Mr. Horn?
One moment, Your Honor.
Defense would only have follow-up if State has questions.
I don't know who was speaking just now.
Sorry. I said defense would only have follow-up if
Okay,
State
all
has
right.
questions.
I understand you'd like to drop charges, ma'am, but just in terms of what you told the police, is it true?
Judge, can I object to this question? I know where it's going, Mr. Horn.
Well, I haven't heard the question, so if you
Okay,
object once
apologies.
you've heard it, so you can complete your question and I'll entertain any objection.
Did you report that the defendant hit you to the police?
No.
Can I object to this question?
Out of emotion.
We're here today in regards to setting terms for release, and the victim is here to discuss her opinion, certainly has the right to be here to discuss her opinion in regards to terms of release. I think having an adversarial hearing in regards to the actual findings of guilt or a victim testimony to the actual acts that happened goes far beyond the scope of initial appearance.
So beyond the scope is your objection.
Yes, Judge.
Response, State?
Your Honor, I'll withdraw the question.
Okay, I sustain the objection. Any other questions, State?
Yeah, it says here that you have 2 children, is that correct? And they were present at the house? They were there?
Afterwards.
Okay. Thank you. Nothing further, Your Honor.
Any follow-up?
Just briefly, would you like to have contact with Mr. Pierre?
Yes.
If there were any future issues, would you feel comfortable calling the police?
Yes.
Nothing further.
All right, just a moment. All right, the bond will be $2,500 as indicated on the aggravated assault, $500 on the battery charge. Should you make bond, Mr. Pierre, you're to have no contact whatsoever with Ms. Claire Pierre. You're not to return to 227 Dempsey Way. However, actually, let's see, he was not living there, was he? If you have personal belongings at that location, then I would grant a one-time return with the assistance of the sheriff's office. You're also not to possess any weapons or firearms, and your next court date will be provided. Thank you.
Okay, sorry.
All right, good afternoon. Your name?
Yeah, I'll let you know.
My name is Rosie Delcas Abreu.
Ms. Abreu?
Yes, sir.
Yes, I'm Judge Epperson. Good afternoon. I have read the police report in this case for the purpose of determining probable cause. I do find probable cause for the allegation of battery, domestic violence.
Okay.
The public defender's office in this case just a second. How often do you receive $1,040 as income?
I get paid bi-weekly.
No dependents?
No, sir.
How much is in your bank account right now?
Probably $8, but I can borrow from my mom.
I didn't hear how much you said.
I have like $8 to my name right now.
Based upon your semi-monthly income, you don't qualify for the public defender, so I will not appoint the public defender to represent you. You have the right to an attorney, but you would have to hire your own, all right? I do find probable cause for battery, domestic violence. Your bond in this case will be $250. You're to have no hostile contact with Noel Moran, and you must not return to 2213 Conway Road. However, with the assistance of the sheriff's office, you can return to that location to acquire personal belongings. That's the only basis, all right?
You said no hostile or no contact?
No hostile. No hostile contact.
Your Honor?
We might need to amend the order. Yes.
I just had a question. So he doesn't live here, he lives in New York. I just haven't been able to take his name off the lease. I live there, I pay the rent. No, none of his belongings are there.
Okay, one moment. Let me just look at the report again.
Okay.
Okay, I'll delete the no return. You're to have no hostile contact with him, but I'll delete the no return provision.
Thank you.
All right, thank you.
Thank you.
Albert, yes, sir, your name?
Alberto Gonzalez.
Okay, Mr. Gonzalez, I have reviewed the police report. Let me take a look at your public defender application. The application's in Spanish. I don't read Spanish. Let's see. How often do you make $3,000?
Once a month.
A month? Okay, so $36,000 a year. You have 3 dependents?
Yes.
What's that? Yes. Yes, I will appoint the public defender to represent you in this case. So you have legal counsel. I've reviewed the report. I find probable cause for battery, domestic violence. Criminal history?
2 felonies, 1 misdemeanor, 2 FTAs.
All right. And from PTR? If you could
does qualify for PTR.
If you could just adjust that microphone down so I can hear you, because I'm having a hard time. I guess must be getting old. Any contact with Ms. Regina Gonzalez?
No, no contact was made. Mr. Gonzalez, your bond will be $250. Based on the
facts underlying the allegation, I'm merely going to order that you have no hostile contact with Ms. Regina Gonzalez. No hostile contact obviously prohibits any acts of violence, but also any threats of violence. You can't throw water on her, for example, or any other acts of hostility. And that'll be the extent of the conditions of release. All right, thank you. All right, good afternoon. Your name?
Fanette Gideon LaFleur.
Ms. LaFleur?
Yes.
Yes, I'm Judge Epperson. I've reviewed the police report. I don't find probable cause for the battery, and the defendant will be released ROR. Oh, I'm sorry about that. Sir, your name?
Is Kendall LaFleur. I'm trying to drop all charges.
All right, does the state or defense have any questions of the alleged victim, Kendall LaFleur?
No, Your Honor. I would just maybe make a probable cause argument. She stated that she grabbed his cell phone from his hand, intimately connected to his body. I would argue that that constitutes a battery, Your Honor.
Okay, defense, anything?
Yeah, I think the battery statute requires actual physical contact for the misdemeanor battery charge, as far as my understanding goes. I don't think that's been met by the arrest affidavit.
Okay, I'm not appointing the public defender based on the application. However,
I think the COVID order still applies this for initial appearance.
okay, provisional appointment then. So I'll accept your argument. And I am going to ROR the defendant, finding no PC. Given the totality of the circumstances, I don't find it rises to the level. All right, defendant will be released on this case today. This does not mean the state can't prosecute the case. It's simply a probable cause. I was letting Mr. Kendall know. All right, thank you. Nirav Patel. Are you Mr. Patel?
Yes.
All right, hi, I'm Judge Epperson. I don't see any paperwork here. I'll make a provisional appointment at the public defender's office, so you have counsel here today. I find probable cause for battery, domestic violence, PTR history.
He doesn't have any Florida history. He has some out-of-state history, possession, drug possession charges. No convictions.
All right.
The rest.
Mr. Patel, I'm setting bond at $250. Should you make bond, you're to have no contact with Kim Patel. You're also not to possess or consume any alcoholic beverages. You must not return to 11557 Amidship Lane. However, you may return one time with the assistance of the sheriff's office for the acquisition of personal possessions, such as clothing, toiletries, or items for work. All right, you can, until further of the order of the court, those are the conditions. You can talk to your lawyer about getting those changed possibly. Next court date will be provided. All right, good afternoon. Your name?
Reginald Taylor.
All right, Mr. Taylor, I'm Judge Epperson. I've reviewed the police report. I do find, let me review the public defender application. I will appoint the public defender to represent you in this case. You have legal counsel.
Judge, if I could briefly be heard on this.
Yes, sir.
I think the affidavit doesn't show domestic violence as a component. I'm not challenging probable cause in regards to the battery, just in regards to the DV component, and that would affect his relation to bond just based on the statute, whereas if it's not going to be domestic violence, there's a presumption towards pretrial or non-monetary release, and I don't think the arrest affidavit alleges anything domestic.
Your Honor, I believe there's been a supplemental report filed as well in this case that alleges 2 more counts, false imprisonment and tampering. I'm not sure if you have that in front of you, Your Honor.
No, I don't.
In full candor, I do not either.
I think it was just put in this morning. If you just give me one moment, Your Honor, I'll just look it up.
History?
5.
I mean, I see he's out on bond.
Yes, he's out on bond. 5 felony convictions, 9 misdemeanors, 2, failure to appears.
Okay. I don't have those other charges state, but on today's case that I've been provided to review, Mr. Taylor, finding probable cause, your bond will be $1,000 on battery. And you're not to have any contact with Ms. Kamana Jones. Unfortunately, you're out on bond in case number 2019 CF 6465. Your bond will be revoked. You'll be held zero bond on that case based upon probable cause for new law violation. Your next court dates will be provided. All right, thank you.
Thank you, Judge.
Thanks. Good afternoon. Your name?
Marquez Atkins.
I can't hear you.
Marquez Atkins.
Marquez Atkins. All right. Mr. Atkins, I will appoint the public defender to represent you in this case, so you now have legal counsel.
Thank you, Judge.
That's the Florida Gator fan there, apparently. Right. Having reviewed the police report, I find probable cause for the first 4 of the 5 counts listed. Probable cause for grand theft motor vehicle, possession of a firearm by a convicted felon, possession of cocaine, and possession of cannabis greater than 20 grams. I'll make a no PC finding on count 5, possession of cannabis. Just a second. History.
9 felony convictions, 10 misdemeanor convictions, and 8 failure to appears.
All right, on count 1, the grand theft motor vehicle, your bond will be $5,000. Possession of a firearm by a convicted felon will be $5,000. Possession of cocaine will be $150. Possession of cannabis greater than 20, $150. And again on 5, no PC, ROR. Your next court date will be provided. Thank you. Jeremiah Birch, I believe, might be next. All right, hello, sir. Are you Mr. Birch?
Yes, sir, I'm Jeremiah
All right,
Birch.
I'm Judge Epperson. There's a couple of matters I'll deal with first. There's a couple of failures to appear. One is a petty theft case. Failed to appear for pretrial conference on February 17th. The court did give you a bond of $250. That's in case 20MM 910. And then there's a second failure to appear in case 20MM 8125, underlying charge, paraphernalia charge, and there's a $2,000 bond for failure to appear. And the court reviewed the sworn affidavit and finds probable cause for possession of cocaine and possession of methamphetamine, possession of MDMA, sometimes referred to as ecstasy. Your bond on the cocaine charge will remain $1,000, $150 on the MDMA case. Should you make bond, you're not to possess, ingest, or consume any illegal substances or any controlled substances without a prescription. A public defender is appointed to represent you, and your next court dates will be provided. All right? Thank you.
Your Honor.
Hello. Sir, your name?
Yes, my name is Rafael Enrique Colon Muñiz Jr.
All right, I have reviewed the police report. Let me take a look at your public defender application. I'll appoint the public defender to represent you, so you have legal counsel.
Where are they?
It's right there wearing the gator mask.
Here, sir.
allowed to tell him something? I mean, it's brief. This is a very simple.
Let me tell you something first, okay? You do have the right to remain silent. Anything you say today, though you think it might help, it could hurt you, and there's a prosecutor sitting there. He could use it against you. And this is a brief hearing simply to determine probable cause. So let me speak first, and then if you want to address the court, I'll let you. All right, I do find probable cause for grand theft of a motor vehicle. And any history?
Yes, 4 felony convictions, 10 misdemeanor convictions, and 6 failure to appears.
Okay, and I'll turn to legal counsel as to whether your client wishes to be heard.
Client would like to wish to be heard. I would advise him not to speak, but he would like to be heard.
Okay, I'll give you a brief opportunity.
Yes, sir. This car cannot be possessed as stolen because the keys were possessed by Jason Velez. They were helping move her into an apartment downtown around sometime in the morning that day. I rode by. They asked me to help. I jumped in the vehicle as a passenger and took off. The keys were possessed by him, and the car was borrowed by Shannon. And her mom, I believe, is Mindy. And this is all in this report as it speaks. But she did not possess all keys, and she lied there. So, like I said, I just got caught up in this bull trying to help them out to move into an apartment. So I should not be locked up. And she lied. She said that the keys were, and there was no breaking and entering in the car. There was no, malfunction. He possessed the key. The key is a keyless silver and black key by Mercedes. So.
Okay. Did you get all that?
Thank you, Your Honor.
Okay, Mr. Columnus, it sounds like, Columnus, sounds like you may have some things that you need to talk to your lawyer about a defense to this charge, okay? You're presumed innocent. I'm simply making a determination, and based upon the sworn testimony I have, and my order will stand. Probable cause finding, your bond will be $1,000.
ROR or something? I mean,
No, your bond, I just reduced your bond from $2,500 to $1,000, okay? And that's where it's going to stay for now. You can talk to your lawyer about modifications. All right, that concludes the hearing.
Thank you, Judge.
Good afternoon. Your name, sir?
Thomas Fairman.
Thomas Fairman, okay. I'll just skip over that. Looks like we're skipping over a couple. Okay, Mr. Fairman.
Denmark, Your Honor?
Denmark's medical.
Oh.
Denmark's medical, okay. Let me take a look at the public defender information. I'm going to make a provisional appointment. Do you wish to waive his initial appearance?
Yes, for Mr. Denmark, I would.
Okay, on the Denmark case, probable cause for all 7 charges, and the bonds on counts 2 through 7 will remain as they're currently set on the police report. However, the bond on count 1 is going to be $15,000, and the defendant is not to return to 1843 Americana Boulevard and is to have no contact with Larry Dominguez.
Sorry, just for clarity. So you're going up from the $5,000 to $15,000 on the burglary charge?
That's clearly what I've done.
No, I just want to make sure.
Yeah.
All right, I'm not arguing.
No, I know. It's based on the totality of what I've read in the report.
Understood.
All right. You are Mr. Thomas Fairman?
Yes, sir.
State, if you wish to be heard, my inclination is that I did not find probable cause, but I'm open to being persuaded differently. The reason being, let's see. Just a second. Oh yeah, multiple persons around contraband, and it's unclear as to why this defendant was either in exclusive possession or had dominion and control in a manner that was unique to him as opposed to one of the other 2 persons.
Judge, can we be provisionally appointed?
Yeah, I'll provisionally appoint the public defender.
I have no response unless the state.
No, Your Honor, I have no response at this time, Your Honor.
Okay, Mr. Fairman, based on the limited information I have before me today, I'm finding no probable cause. You'll be released on this case today. Now, that does not mean that the state may not file charges. That's up to them. They can still prosecute this case, but you'll be released on this case today.
Understood.
Thank you.
Thank you. No PC.
No PC, ROR. Your name, sir?
Carlos Ferrer.
Carlos Ferrer. All right, sir, you're here because of a failure to appear on a grand theft charge in case 2020 CF 14395. The court will appoint the public defender to represent you in the case. And your bond, because it was a failure to appear, the court did set your bond at 0. It'll remain 0 at this time, and your next court date will be provided. All right, thank you.
You have two cases. You have two.
Had 2 cases. I'm sorry, Deputy. He had 2 cases.
Two FTA.
The other one was a failure to appear in the bond. My bad, as they say. Mr. Frere, I neglected to mention your second case. There was a second case for a grand theft where you failed to appear. In that particular case, however, the court did give you a $5,000 bond, and that's in case 20 CF 14393. Thank you. Public defender appointed on both. Your name?
Clifton Hall.
A little louder?
Clifton Jermaine Hall, sir. Clifton Jermaine Hall.
Okay, just a moment. I have you here. All right, sir, you were arrested on an outstanding warrant. A court already found probable cause for failing to register as a sexual offender as required by law.
Huh?
Just a second.
Getting bond.
Okay, I'm setting your bond in the amount of $2,500.
Thank you.
You must register as required by law upon your release from custody.
So I go today. When I get out, I go to first thing Monday morning, sir.
Just you have to comply with all registration requirements upon your release from custody. All right,
Yes,
sir?
sir. Thank you, sir.
Yes.
Who was that? I'm sorry.
That was Clifton Hall.
What happened to,
Hallo.
Your Honor, what happened to Jaden Gonzalez?
Yep.
Thank
I was
you.
wondering the same. Thank you for asking. I just set it aside. Oh, well. Okay. That's the one that bonded him. All right, sir, your name?
Kenneth Kilroy.
All right, Mr. Kilroy, one moment. We have, I think, 4 cases here. Okay, Mr. Kilroy, I'm appointing the public defender to represent you in this case, so you now have legal counsel. For today's hearing, your attorney's here in the Florida Gator mask. All right?
All right.
I've reviewed the 4 reports. The court will reference these by case number in 21 CF 2384. I find probable cause for burglary of a conveyance and theft. And before I determine bond amounts, history?
He has no history, Your Honor.
All right, so count 1, burglary of a conveyance, your bond is going to be $1,000. On count 2, theft, it'll be $250. In case number 21 CF 2387, I find probable cause for burglary of a conveyance and theft. Your bond on the burglary will be $1,000 count 1 and $250 on count 2 theft.
Judge, if I could be heard briefly.
Okay.
Only in regards to, not in regards to a burglary, just specifically to armed burglary. I don't believe the arrest affidavit alleges any specific devices or firearms or weapons that could have been classified as armed for the charge. I believe, as I heard, you were just setting it as a regular burglary, but just to make.
I am. I'm following what you're suggesting, and that is merely that I'm finding probable cause for burglary, not armed burglary in each one. If I need to go back and get the statute, but it's burglary. So picking up where I left off on 21 CF 2387, I think I announced the bonds. It was at 1,000 on one and 250 on count two. And then turning next to 21 CF 2385, count one, burglary of a conveyance. Your bond will be 1,000 on count one. On count two, carrying a concealed weapon, it would be $500. And on the fourth case, 21 CF 2386, attempted burglary of a conveyance, your bond on that case will be $500. So those are your bond amounts. And Madam, I was going to say Madam Clerk, but from pretrial release, the court's findings of probable cause did not involve the armed. Is the defendant qualify for pretrial release? Bond with pretrial release conditions?
Yes.
Okay, so you're going to, if you make bond, Mr. Kilroy, you're going to have to follow all the rules of the pretrial release program. Your next court dates will be provided in each of these. Thank you.
Thank you.
So it's bond plus pretrial release on
Each case.
Okay, and then the statute number?
Yeah, I'm going to, it's
Burglary.
burglary of a conveyance.
Yes.
And it is 810-0. Let's see. Eight 810-02. 810-02.
Thank you.
Straight burglary. Do this to 810-02 subsection 4B. Thank you. Your name?
Yes, my name is Teofilo Kimani, Your Honor.
All right, Mr. Kimani, there's a couple of matters here. First of all, there's a case in which you failed to appear. It's 20 CF 11638, a cocaine and paraphernalia charge. The court did give you a bond of $1,000 on count one and $100 on count two. That was a failure to appear for pretrial conference. There's another case, and I've reviewed it today. And by the way, I'm appointing public defender to represent you in these matters. Counsel's here to your left wearing the gator mask.
Okay.
The court finds probable cause for resisting an officer without violence as well as trespassing. Your bonds will be $100 on the resisting without violence and $100 on the trespassing charge. You're not to return to the target at the Millennia Plaza Way. Don't go back to that location. Did you get all of that?
Yes.
All right, your next court dates will be provided. Thanks.
Judge, on that last case, you had bond with 100 and 500, you state the bond?
What was that guy's name?
When I just now did?
Yes.
It was 100 on count one.
I don't have a arrest affidavit for. Madam Clerk, I don't have an arrest affidavit for that defendant. Is it possible you could just provide me the name?
I just found it.
The one we just did?
Yes, ma'am.
It's, you probably can pronounce it.
Okay, let's see.
On page 21.
Theophilo, that's how I'd say it, Theophilo, spelled Theophilo. That would be the compound. In the Greek, it would be God and brother. Theophilo.
Theophilo.
Theophilo Kimani, last name Kimani. Brother of God. Yes. All right, your name, sir?
Sean Manella?
Mandela?
Yes, sir.
Can you spell your last name? Because there was a discrepancy in the report.
Manella.
So there's no D in it.
They messed up.
Well, here's my question. Is it spelled, is it Manella or Mandela?
Manella.
Without a D?
Yes, sir.
Okay, State, as the prosecutor, you can take note of that if you wish to amend any documents. I've reviewed the police report. I find probable cause for burglary of a structure and possession of burglary tools.
But, sir, I was walking through with my bike, and as I was going out of the fence, he stopped me. Since I had the two screwdrivers that I had needed for my bike, that's what he came at me with, since I was carrying it.
Mr. Mandela?
Yes, sir.
First of all, you are presumed innocent of these charges. The state has to prove your guilt beyond all reasonable doubt to a unanimous jury. You might have defenses to the charge. The purpose of this hearing is for me to review the sworn affidavit to determine whether there's sufficient probable cause, which simply means more likely than not that a burglary occurred and a possession of burglary tools.
Thank you.
What I have read would be what we call circumstantial evidence establishing probable cause for burglary and possession of burglary tools. You may have a great defense to this charge, and you'll need to talk to your lawyer about that. But I do find probable cause has been met. Criminal history?
He only has one misdemeanor conviction.
What? I didn't hear you.
He only has one misdemeanor conviction. No out-of-state history.
Okay. Does he qualify for pretrial release?
No, Your Honor, we couldn't verify his community ties. He stated that he was homeless and didn't have any emergency contact information.
Okay, Mr.
Briefly interject. I think we can do a bond if not, if pretrial release wants to try to redo an interview, I think we could do pretrial release and then if not, set a bond otherwise.
Okay, if the defendant has, what was the misdemeanor?
Brawling, fighting.
Okay. The court is fine with pretrial release if he qualifies. Otherwise, the bond on the burglary of a structure is going to be $500, and it's going to be $250 on possession of burglary tools. So that's the bond. Bond amounts. I mean, I don't know how to word this.
Bond or PTR.
Yeah. Bond, yeah, bond or pretrial release if he qualifies. Otherwise, the bond amounts I've just articulated will govern.
Yes.
All right, and you're not to return to the Faith Assembly where this offense allegedly occurred. Don't go back to that property located at 2643 Econ Trail.
Sir, I was just cutting through there.
Okay. Don't cut through there then anymore, all right?
That was the plan. That's why I was cutting through, sir.
All right. Have a good day. Thank you.
Thank you, Judge.
Huh? All right, sir, your name?
William Mays.
Okay, Mr. Mays, I will appoint the public defender to represent you based upon the information I have. So you have legal counsel here to your left, sitting to your left. I've reviewed the police report and I find probable cause for possession of methamphetamine and resisting an officer without violence. Your bond will be $1,000 on count one, the possession of methamphetamine, and it'll remain $100 on the resisting without. Unfortunately, you are out on bond on a similar charge. And the court's going to go ahead and revoke your bond in case 21 CF 95, and you'll be on a zero bond on those cases, all right? Public defender's been appointed to help you.
That's what I don't need, Your Honor.
Your next court dates will be provided.
You revoked both cases, Your Honor?
I revoked, I was only aware of the...
Because he's out on bond on two.
Okay, 21 CF 95, I just revoked, zero bond, and then the other case?
Is 2020 MM 008779.
And is that a trespass?
Yes.
Yeah, I'll leave that alone.
No action.
No action, thank you. No action will be clearer than leave it alone. Thanks for the prompt. All right. All right, ma'am, your name?
Yes, Brianna McFarland.
Okay, unless you have an argument, State, I didn't see probable cause for count one. Count one is providing false information adversely affecting another, and by the officer's own words, he describes a potential adverse effect on another rather than an actual adverse effect on another. And I believe the statute, which makes it a felony, necessitates a showing of actual adverse effect. The defendant recanted before the named party actually incurred any detriment.
Your Honor, I have no response.
All right, so I find no probable cause with respect to count one, and the defendant will be ROR'd on giving false name adversely affecting another. I do find probable cause for count two, which is providing false identification information to a law enforcement officer while lawfully detained. That's a misdemeanor. History?
3 misdemeanor convictions and 2 failure to appear.
Judge, if I could briefly be heard, I understand right as of now, she's being held no bond on a failure to appear. As I understand what Ms. McFarland has told me, is she has a private attorney who has since put in a motion to quash the capiases for the failure to appear based on contact later on in the case line. I don't know what impact it's going to have on your ruling today, but I think it was important for the court to know.
All right. I'm going to keep your bond at $100 on count two. All right, thank you.
Yeah, you're good.
And you're keeping the FTA, is it?
Thank you, Judge.
No bond. The FTA, they stay at no bond?
I didn't even realize that. I missed it.
Well,
Okay.
She celebrated without full information. All right.
well, I don't think there's going to be a miscommunication. She understands that those are no bonds. She just would
Right.
like the court to know.
Okay, then I'm not going to bring her back in. It's, are you willing to waive, given the fact that you've
Yes.
already discussed it? Okay. Council's willing to waive then. Then on 2019 CF 6080, there was a failure to appear, and the bond was 0. That's a fleeing and eluding, ag fleeing, resisting. It'll remain 0 on the failure to appear, and she'll get a court date. All right. Your name, sir?
Norman L. Perez.
Norman Perez Morales?
Yes, sir.
State, in this particular case, unless you have an argument, I was going to afford you 24 hours to supplement the record to establish probable cause. The officer indicated that when a warrant was executed at 2 locations that were belonging to the defendant, there was property recovered that was stolen property. In the court's assessment, there just needs to be more specificity. The officer also indicated that the defendant is known to drive a PT Cruiser, which is a vehicle that's been involved in burglaries, but doesn't provide any more detail as to putting the defendant, tying the defendant to it in terms of ownership or any other circumstantial evidence. So I'll give you 24 hours. We're going to reset this, and I'll hear it again tomorrow. I'm not making a finding of no probable cause. I'm simply resetting, and the statute allows the state an opportunity to get more information. Thank you.
Thank you, Your Honor. Thank you.
Your Honor, again, I have Melendez.
Yeah, me too.
And
Mark Thomas
Payne.
Melendez?
Oh, no, that went.
You did Payne. Payne was pushed out.
Yeah, just Melendez.
Yeah, I missed that one too. I just kind of set it aside when he didn't come in. Can you all advise on Mark Thomas Melendez?
You have a booking number for me?
Couldn't hear you.
A booking number. It's not on your document. What's
It's on the docket, top of page 12.
It's 21004912.
Defendant posted bond.
Say again?
Defendant posted bond.
Oh, okay, that makes sense. Your name? Step right up to the microphone.
Alondra Rosado.
Alondra Rosado. All right, State, this is another case in which I'm open to an argument, but I'm inclined to find no PC. There's no details in the report as to the timing of the theft of the vehicle from another county. as between when this person was in possession of the vehicle.
Your Honor,
And there were multiple occupants.
the state would just ask for 24 hours to get more information in order for you to make a probable cause determination.
Actually, it was out of Orange County. Let's see. Actually, the court is going to make a finding of probable cause to the lesser included offense of trespass of a conveyance. And on the trespass of a conveyance, the bond will be $500. Just one moment. Defendant's ROR on a no valid. ROR on a VOP? How does that happen? All right, that's it. I'm not going to take any action on the other matters. All right, thank you. Time out. I'm sorry, I did it again. No. There's a second case. There's a theft, and that's 21 68.
Yeah.
State, do you have an argument for the theft on that case? A PC argument? It sounds like that this officer's alleging an independent theft from the grand theft motor vehicle, but I don't see it.
I don't either, Your Honor. If I could just have one more second to just, maybe I'm missing something.
Mm-hmm.
No, Your Honor, I have no response.
All right, so I'm going to find no PC on that theft, and if it'll be ROR'd on it. Thank you.
Judge, did you take no action on all 4 of the cases?
Yes.
Okay.
It's 810.08 trespass conveyance. 810.08. Thank you. Your name?
Kenneth Santiago.
All right, sir, I will appoint the public defender to represent you in this case. Just a second. You have that chart there?
Yes, it's here.
Okay, sir, how much money's in your bank account?
Right now, 1,400 to 1,500.
Is the BMW paid off?
Yeah.
What would you estimate it's worth to be? I know it's a 2004.
Oh. $500, $600.
All right, it's a close call, but I'm going to appoint the public defender to represent you in this case. You have legal counsel there to your left. I've reviewed the police report. I do find probable cause for aggravated battery, aggravated assault with a firearm, and battery. Criminal history?
0 felony convictions. He has 1 misdemeanor conviction, was possession of cannabis.
Okay. These very serious allegations. On count, yes, sir?
I would like to hear what you had to say first, and then I could have.
No, I'll give the last word.
I was going to say the bond on this should be still discretionary. I know we're not doing a full Arthur hearing now. We discussed this earlier today, and that could be heard in the entire division. I would just say that the court does still have discretion to set a reasonable bond. I think that would be appropriate in this case. Given the facts, it is a serious allegation, but given the facts, I think an appropriate bond is best.
All right, state any argument?
Your Honor, I would just argue that the affidavit alleges proof evident presumption great based off of eyewitness testimony that the defendant.
Well, but this is not a capital offense and it's not a PBL, so that doesn't even. So I think the defendant.
I know it's not a capital case or proof evident. I would just ask that the bond be set reasonable. I understand that I misspoke and said an Arthur hearing.
Okay.
That was a misspeak on my behalf.
All right, with respect to count 1, aggravated battery with a firearm, I'm setting your bond at $15,000. On count 2, ag assault with a firearm, setting bond at $2,500. And count 3, battery, your bond will be $500. Should you make bond, it's very important that you have no contact whatsoever with Collins Sunday. You're not to return to 1303 Kirk Street. Do you have personal belongings there?
Yes, I do.
Okay, I would grant a one-time return with the help of law enforcement for the purpose of acquiring personal belongings such as clothing, toiletries. You're not to possess any weapons or firearms. Okay. All right, and your next court date will be provided.
Okay, thank you.
Thank you.
Again, apologies for my misstatement, Judge.
It's okay.
And opposing counsel.
It's not a DV case.
Sir, your name?
Dante Scott.
All right, Mr. Scott, I'm Judge Epperson. I've reviewed the police reports to determine probable cause. I'll appoint the public defender to represent you in this case. You have legal counsel. I find probable cause for trafficking MDMA or meth, possession of cannabis less than 20 grams, and possession of drug paraphernalia.
But I accept.
Given the quantity of the meth, your bond on count 1 will be $50,000. Your bond on counts 2 and 3 will remain $100. Should you make bond, you're not to possess or consume any illegal substances or any controlled substances without a prescription. Your next court date as follows, or will be provided. Thank you.
Thank you, sir.
Your name, sir?
Trenton Thomas, sir.
All right, Mr. Thomas. I'm going to make a provisional appointment at the public defender's office. I have reviewed the police report and find probable cause for fleeing and eluding, driving while license suspended, and grand theft of a motor vehicle.
I'm sorry to interrupt. Pretrial services, I think this is one of the ones.
It's out on bond?
It's just out on bond. That's all they provided us. Does he have a new charge?
He has an open case that 2021 CF 002201.
Okay, so this case goes back to January 8th.
Yes, sir.
I'll show you do you want to see this?
Can I have the new case that you have? Because we never received it. We only have the affidavit. You have the 2019 case? Is the new case?
That's not the new case. You need the affidavit for the new case.
We have the out on bond form and that's it.
Let me print it out.
I reviewed this with the impression that it was new, but it's January 8th.
Yeah, so that's the case.
Yeah.
I think the docket reflects the new case, unless there's another one I'm not aware of. There's the allegations for the case, under the case number that I have for the docket, under case number
Can you do something with that? That's the new one.
2021 CF 2201, alleged February 22nd.
I have that he was IA'd on the 23rd.
So what are we doing here today?
It's in there.
There was conditions set.
Was any action taken on this case? The old case?
I don't think it was addressed at that time.
No action was taken
The
on
PC finding was made in the, PC finding was made on 223 on this new case.
Yes, Judge. You want me to print it out?
Yeah.
The PD was appointed and
Okay, so it looks like the defendant has already had his initial appearance.
Yes, sir.
On case 21 CF 2201, and a probable cause determination was made. Grand theft motor vehicle, I believe by Judge Strobridge. And I'm going to take a look at that.
Yes, sir.
And at the time, defendant was out on bond
Yes, sir.
in case 19 CF 422. And the court is going to revoke bond in case 19 CF 422. Defendant will be held on zero bond based upon the new law violation. And public defenders appointed, and next court dates will be provided. Thank you. I'm not sure if that's why they put it back on, but.
Is that why it was put back on? I was going to ask the same.
Yeah,
I was going to ask the same question. I was trying to figure out why it was put back on as well.
I don't know.
Okay.
I don't know. Your name, ma'am?
Hi, it's Stephanie Waterman.
Okay. Did Ms. Vega bond?
Better?
Kiara Vega was the one I was seeing next, but maybe she bonded. Kiara Vega.
You have a booking number for me?
Booking number 2100-4898. 2100-4898.
Yeah, she posted bond.
She posted bond, okay. And then I also had John Vetter. John Vetter is? Okay, so 21 CF 2373, I want to address it. John Vetter is medically restricted. I'll provisionally appoint the public defender waiving initial appearance.
That's correct, Judge. As long as there's a finding of probable cause found, I have no issue waiving initial appearance.
Okay, so it was an arrest warrant case, and Judge Karsten set bond at 500. It'll remain 500. Court date to be provided. Okay, Ms. Waterman. I will appoint the public defender to represent you in this case, so you now have an attorney. I'm Judge Epperson, and this is your counsel here to your left for today from the public defenders.
Okay.
I've reviewed the affidavit. I find probable cause for count 2, trespassing, given the totality of circumstances. I find no probable cause for counts 1 and 3 because of more than one person in the vicinity of contraband without any evidence of dominion and control by this defendant. On the trespass charge, the bond will be $500, and you're not to return to the location at 1414 22nd Street. Do not go back to that location, that house, all right?
Your Honor, if I may make a brief PC argument?
Yes.
Just on count 3, the affidavit specifically alleges that the paraphernalia was away from the other defendant. So I do have no response for your PC argument on count 1, but I would point to that for count 3, Your Honor.
As to count 3, what about dominion and control, since it's constructive?
If I could briefly be heard on this anyway, that charge, the paraphernalia charge, as far as count 3, carries a strong presumption towards ROR and non-monetary release conditions either way, based on Florida statutes number 907.041. So if we could order ROR on that charge, without a finding of probable cause, I think that's certainly best. That being said, even if there was a finding of probable cause, I think the statute still leans sort of strong presumption towards ROR. I think that's still best given the fact.
Okay. I respect the state's argument because it is characterized in some respects as being closer to her than the other party. But I'm going to stand by my original ruling, no PC on counts 1 and 3, ROR on counts 1 and 3, PC count 2, $500 bond. Don't go back to that location. And your next court date will be provided. Thank you. Okay. So, waiting for the next one.
I thought we were gonna stop at the felony.
No.
Oh, okay. I had reviewed a few more, but we can stop right here. It'll only take me about 15 minutes to 20 minutes to review the rest, and then we'll reconvene. I think I'm going to set my latest record here today. We had some technical issues with the, I did with the laptop over at Juvie, so it took a
I
while.
think it was all of us, Your Honor, this one.
Not a problem. Judge, I used to be a teacher. We used to call this a bio break, so give me a chance to have a bio break.
Okay, so we'll be in about a 20-minute recess, and then we'll finish up. Thanks, everyone.
Judge, do you Adam Phillips over to the side?
Yes, I do.
Okay, can I see it? I just want to add.
Yeah, that was a weird one.
Oh, that's another one.
Yeah, Dante Sylvester.
Yeah, that's another one. You're just addressing the order revoking, so we can do that when we come back.
Okay.
And then there was a.
Yeah,
Adam Phillips.
Yeah, I definitely set that aside. Here it is right here.
Can you look this case up and see if you bonded?
I hope he did. That's a weird one.
What's the booking number?
2100-3985.
Okay, so these are the ones I'll start with, but
No, he ain't bonded.
Okay, so we'll call it when we come back. And then, I don't think they have this case. Do y'all have Dante Sylvester on your list? I don't think they got it.
But they told me everything was taken care of.
Yeah, so he's gonna call that when he comes back. Okay. And then Dante Sylvester.
I don't have that person in the document.
Don't worry about it.
We gonna worry about it?
You can let them know, but
I was told that he was coming to court. He posted bond, but he has an open case.
Yep.
No, don't worry about it. I was just previously told that corrections was notified to still bring him to court.
One second. Just don't talk, okay?
Oh, all right.
And with initial appearances, we can go ahead and continue. Sir, your name?
Erwin. Oh, sorry. Can I take my mask or no? Okay. Erwin Didios.
Okay, Mr. Didios, I'm Judge Epperson. You're before the court for a failure to appear in case 21 MM238. The trial court did give you a bond of $2,000 on this case, and that is your bond amount, and your next court date will be provided. The public defender's office will be appointed to represent you. Thank you.
Thank you.
Sir, your name?
Alonzo Allen.
Alonzo Allen. Okay, Mr. Allen. I'm Judge Epperson. I will appoint the public defender to represent you in this case, so you now have an attorney.
Okay.
Been arrested on, there's a couple of traffic offenses, driving while license suspended with knowledge and attaching a tag to a vehicle that it was not assigned to. Your bond in each case is $500, and your next court date as follows. Or it'll be provided. It'll be provided to you.
What? So I got bond, right?
You have a $500 bond in each case.
Okay.
Judge, if I could briefly be heard on release conditions.
Briefly be heard on what?
Release conditions. Florida statute leads heavily towards non-monetary release for non-violent charges. I can give the statute number. It's 907.041, and then subsection 3 is non-monetary release. I understand that pretrial release has every right, and they've acknowledged it was a high-risk assessment. I would ask that a non-monetary condition be set, but I understand if you would disagree.
Well, I was digging through here to try to find his history. Could you go over his history?
8 felony convictions, 5 misdemeanor convictions. He has 3 failure to appears.
I'm going to keep it as I announced, but I understand your argument. Sir, your name?
Randall Evans.
Okay, Mr. Evans. Can you afford to hire your own lawyer?
Yes.
You can?
Yes.
Okay, then the Public Defender's Office will simply be standby counsel today at initial appearances here to your left. I've reviewed the affidavits. I find probable cause for driving under the influence, commonly referred to as DUI. Your bond will be $500. If you make bond, you're not to possess or consume any alcoholic beverages or go to any bars, and your next court date will be provided. Thank you.
Thank you.
Your name, sir?
Jeff Hoover.
All right, Mr. Hoover. Hi, I'm Judge Epperson. You've been in custody for failing to appear on a driving while license suspended charge. The trial court did give you a $1,000 bond. I'm appointing the public defender to represent you to help you on your case. That is your bond amount, and your next court date will be provided. The case number is 20 CT 2959.
I came showed up for that court date, sir, and they told me I wasn't supposed to be here.
Say that again?
I showed up for the court date, and they told me I wasn't supposed to be here until the 15th.
Okay, if you don't think you willfully failed to appear, you'll need to discuss that with your attorney because the documentation I have suggests otherwise, but you have an attorney.
Paperwork showing at home.
All right, thank you.
Yes. If I could interrupt again, Your Honor, and just Voight Reinhard.
Yeah, I missed him too.
But you're seeing it at 1,000.
Yeah. Thanks. Your name?
Travis Urbano.
Okay, Mr. Urbano, just a second. I will appoint the public defender to represent you in this case, so you have legal counsel. This is your attorney here today. Having reviewed the police reports, I find probable cause for driving while license suspended, driving under the influence, refusing to submit to a breath alcohol or blood alcohol test with a prior refusal from 2014. Your bond on the driving while license suspended, which is case number 21 CT 172, will be $500. Your bond on the DUI, which is 21 CT 173, will be $500. And your bond on the refusal to submit to a breath test in 21 CT 174 will be $500. Should you make bond, you're not to possess or consume any alcoholic beverages or go to any bars. Thank you.
Thank you, Your Honor.
She's currently out on bond.
One moment, sir. All right.
Yes, sir.
There's another matter I need to take up, and it's case 20MM 7607. It appears that you are out on bond for a battery case.
No, I didn't get arrested for the battery, sir.
No.
It's a
My mistake. One moment.
2020 CF 010427.
Okay, just a second. Okay, possession of cannabis with intent to sell, Xanax, possession of cannabis, possession of paraphernalia, possession of prescription without fraud. All right, sir, unfortunately, I am going to revoke your bond in 20 CF 10427. You'll be on a zero bond on that case. I will appoint the public defender to represent you. Yeah, go ahead.
Your Honor, please, honestly, that case, I already have a lawyer and everything, and they have pushed it back. They dropped everything on it except for the felony possession of Xanax. Can I please have a bond? I understand where you're coming from. I'm sorry. Please, Your Honor, can I have a bond? I understand what's going on. I see where you're coming from by revoking it, but please, can I have a bond, Your Honor?
Right, not on that case today. You can't on that case today. You can talk to your lawyer about it going before the court. Thank you.
You're not addressing the MM case.
Take no action on the MM case. Yeah, take no action on the MM. That's the battery.
Judge, can we just remand him for a nominal amount on the MM just so that you can gain time while in? Just
Nah, I'm gonna let him enjoy his liberty on that number, case number.
Okay.
All right. Sir, your name?
Yes, Hardaway.
Okay, Mr. Hardaway, you've been arrested for trespassing. I reviewed the police report and I do find probable cause. Public defender will be appointed to represent you in this case. Anything from the public defender's office in this matter?
Well, briefly, I believe the state has conveyed to me this possibly the state has an offer on this charge.
Yeah, just give me one.
Torn, offer?
Yes, Your Honor, one moment, I'm sorry. Yes, Your Honor. At this time, the state's offer is an adjudication of guilt to count 1, trespass, entry on property unlawfully, 87643. Credit time served, no return to the scene, court cost, cost of prosecution, cost of defense, Your Honor.
Theoris Hardaway, 21MM 1411.
Mr. Hardaway would like to resolve this case today.
Mr. Hardaway, if this is true, raise your right hand to be sworn. Do you solemnly swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
You can put your hand down. Mr. Hardaway, you have the right to a trial, but if you plead guilty to this trespassing charge, you're giving up that right. Do you understand that?
Yes.
Have you had a chance to talk to your lawyer about this?
Yes.
Are you under the influence of drugs, alcohol, or medication today?
No, I'm not.
All right. Do you wish to plead guilty to trespassing as alleged in the charging affidavit?
Yeah, guilty.
Is the defense waiving any deficiencies in the charging instrument?
For the purposes of the plea.
All right, Mr. Hart, well, for any other purpose, are you maintaining?
Just for the plea.
Okay.
Well, to resolve the cases, we'll waive deficiencies.
All right, thank you.
Yes.
All right, just making sure. Mr. Hardaway, I'm accepting your plea of guilty, finding a sufficient factual basis to do so. I will adjudicate you guilty and sentence you to 2 days in the Osceola County Jail with credit for the 2 days you've already served. There's court costs that are mandatory, $273, $50 cost for the services of the public defender for a total of $323. I'll give you 120 days to pay that to the Orange County Clerk of Court, and don't return to the McDonald's located at 2701 East Colonial Drive because there's a trespass warning there, okay?
All right.
All right, you'll be released on this case today, subject to any other holds. Thank you.
Okay, thank you, Judge.
Judge, if I'm just trying to get ahead, I see next on the docket is Jarvis Hardin. I'm showing the case is already closed. I'm frankly not sure why.
Let's see who this is.
Because we did it in move-ups.
Oh, you're right.
Okay.
There you
Sir,
go.
you can step up to the microphone there and state your name.
Sean Lyle. Sean Lyle.
Okay, one moment. You say Sean Lyle?
Sir.
Okay, Mr. Lyle, I will appoint the public defender to help you in this case. I've reviewed the police report. I do find probable cause for petty theft. Just a second. Defendant is presently out on ROR for case number 20 CF 11857. All right, Mr. Lyle, theft is an intentional offense that's alleged. I'm revoking. You want to be heard?
No, Judge. Oh, I would like to hear if you're intending to revoke the bond, ask it not be revoked based on that he's only here today on a new allegation of a misdemeanor charge. That being said, if your inclination is to revoke his bond on the previous bond case, I would just ask to be heard in the trial division.
You would ask what?
I would say that it needs to get resolved in the trial division if you're inclined to revoke bond on the other one.
Okay. I'm revoking bond in 2020 CF 11857. Defendant will be held on a zero bond on that case. Your bond will be $500 on the theft allegation. You're not to return to the Speedway located at 13707 West Colonial Drive. Don't go back to that location. Public defenders appointed on both cases. Your next court dates will be provided. Thank you. Sir, your name?
Elliot Preston.
All right, Mr. Preston, just a moment. I'm Judge Epperson. I will appoint the public defender to represent you in this case. I've reviewed the police report. I find probable cause for petty theft and trespassing. Just a second. The little box wasn't checked. I see that there's maybe an open case in 21 CF 33 with possession of a controlled substance, destruction of evidence, and paraphernalia. Is that an out on bond type of case?
Yes, he's out on bond.
Oh, your bond is revoked in that case, Mr. Preston, and you're held on zero bond on 2021 CF 33. On this case, new case, theft, your bond will be $500, trespassing $500, not to return to the Walmart at 3101 West Princeton Street. Public defender represents you on both. Next court date will be provided. Thank you. Morning. Your name? Okay, ma'am. I'm Judge Epperson. I will appoint the public defender to represent you in this case. I've reviewed the police report. I do find probable cause for the offense of theft. PTR history?
3 misdemeanor convictions and 3 failure to appear.
All right, bond will remain $250, and you're not to return to the Walmart located at 2271 North Cimarron Boulevard. Your next court date will be provided. Thank you.
I have an offer.
All right, good afternoon. Your name? Ms. Robinson, I'm Judge Epperson. I have reviewed the police report. I do find probable cause for possession of drug paraphernalia. Public defender is appointed to represent you and help you in this case.
Judge, if I could be heard briefly, I understand the state has an offer you'd like to announce on the record. That being said, I'd like to get the offer first, but.
Your Honor, at this time, the state's offer is an adjudication of guilt as to possession of drug paraphernalia, 893.147, credit for time served, and no return to the scene, family dollar, and court costs, Your Honor, cost of prosecution, cost of defense.
That being said, Judge, if I could have a brief moment, also, I'd like to hear your impression. As I've cited the statute before, I can re-give you the state number. This case still has a heavy preference towards non-monetary release, and I think it might also qualify for the state's diversion program for paraphernalia. That being said, I'd like to talk to my client briefly about it. That being said, if you would perhaps give an impression in regards to your stance on ROR, given the charge.
I don't think I'd be RORing.
Okay. So. You'd like to resolve your case?
I'm done. I'm gonna go home.
Like to enter a plea?
I'm sorry.
Well, that was the offer this.
I'm sorry.
No, that's,
I think this.
Okay, Ms. Robinson, are you right now, as you're standing there, under the influence of any drugs, alcohol, or medication? Huh? Okay, so just take a breath, all right? I know you got a mask on, but take a breath or two. I'm going to ask you some questions, okay? So just pay attention to the questions and answer them. All right, we're going to need to begin with you raising your right hand to be sworn. Do you solemnly swear that the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
You can put your hand down. Do you want to give up your right to a trial and enter a plea of guilty to possession of drug paraphernalia?
Yes.
Have you talked to your lawyer about it? Has anyone made any promises or threats to persuade you to plea?
No.
Is the defense waiving any deficiencies in the charging instrument?
No.
if we can get through the plea colloquy, the defense would waive any deficiencies in the charging instrument.
And do you, as counsel for the defendant, do you have any reservations about your client moving forward with a plea today?
I don't have reservation in regards to her competency. I would, if I could reset to the back end so I get a couple of minutes to talk to my client and maybe address something in the meantime. Just that being said, if the court isn't inclined, I don't have any reservations in regard to her capacity to understand the charges or willfully admit or deny to what occurred.
Go ahead and finish talking to her now then.
Yeah. My concerns have been abated.
Okay. Ms. Robinson, just to finalize now, do you wish to plead guilty to possession of drug paraphernalia?
Yes, sir.
Having read the affidavit, I find an adequate factual basis to accept your plea of guilty. I will adjudicate you guilty and sentence to 2 days in the Osceola County Jail with credit for, in the Orange County Jail with credit for the 2 days that you've already served. Ms. Robinson, there's court costs in the amount of $388 and a $50 cost for the services of legal counsel, so the grand total is $438. And I'll simply order that you pay that in full within 180 days to the Orange County Clerk of Court. You have 30 days to appeal. You'll be released on this case today, subject to any other holds.
Sir.
Thank you. Your name, sir?
Mr. Scott.
All right, Mr. Scott, I'm Judge Epperson. I will appoint the public defender to represent you based on the application I've seen. I've reviewed the police report. I find probable cause for false alarm of a fire and trespassing.
Wait, false alarm of fire? No. My bond was I only had trespassing. False alarm of fire, where it came from?
Okay, that came from the charging affidavit. You're presumed innocent, but according to a material witness, they saw you pull a fire thing down, but you're presumed innocent. Your bond on count 1 is going to be $500. Your bond on count 2 will remain $100. Public defender's appointed, and you're not to return to the location of the Quality Inn located at 1850 West Land Street. Don't go back to that location. Your next court dates will be provided.
Yeah.
Thank you.
He has an open case, Your Honor.
Oh, sorry, Mr. He needs to come back. Mr. Scott,
Case from well.
you were indicating.
I ain't got no open case from nowhere. I wasn't on no bond.
2020 MM 008757 AO.
What? No.
8754?
No.
Yes.
Okay, what kind of case is that?
The misdemeanor, trespass and false alarm.
I'm sorry, I cannot hear you.
Oh. It's a trespass and structure and false alarm.
That's what I'm here for now.
It is. The same,
It's a
okay.
different case number.
Right now, I'm just here for a trespass. Ain't no fuss along on my paperwork that they booked me in on.
All right, I'll take no action on that. Thank you.
Thank you, Judge.
Your name, sir?
Ina Wilkerson.
All right, Mr. Wilkerson, I'm Judge Epperson. I will appoint the public defender to represent you in this case. I've reviewed the police report and I find probable cause for trespassing as well as possession of drug paraphernalia. Unfortunately, you are out on bond in case 20 CF 10824. With the new law violations, I'm revoking your bond in that case and you'll be held on a zero bond. Your bonds on today's cases will remain the same, 500 on the trespass and 500 on the paraphernalia. Your next court dates will be provided.
So you took my bond?
I took your bond on the felonies that you were out on bond for when you allegedly committed these new crimes, yes. All right, so you have no bond on that case. Your name, sir? Hey, Mr. Kennedy, you've been arrested on a warrant from another county, that being Marion County, on a stalking charge. The issuing court set no bond. Marion County will have a reasonable amount of time to pick you up on the warrant or you'll be brought back before the court. All right? Thank you.
Judge, this is a general question I think might apply, but either way, are we still having to coordinate with the other county in regards to resolving those cases?
I believe that the judges that are here on site do that. Judge
Gibson and Bain.
Yes, Judge Gibson and the other court do coordinate, yes.
Okay.
We just don't stop our proceedings though and do that. All right, your name, sir?
My name is Eric Sullivan.
Okay, Mr. Sullivan, been arrested on a warrant from another county on a violation of pretrial release on a theft charge. That's Brevard County, 20 MM 41769. The judge in that county did give you a bond. It's a $1,000 bond, and they'll have 48 hours to pick you up. All right?
Yeah, 48 hours to pick me up.
48 hours, yes. Thank you.
Thank you.
Anthony Page. Are you Mr. Page?
Sir.
All right, I'm Judge Epperson. Hello. Good, thank you. You've been arrested on an alleged violation of probation in 19 CF 890. The underlying charge, carrying concealed weapon and possession of controlled substance. Judge Young set your bond at 0. I will appoint the public defender to represent you in the case, and your next court date will be provided. Thank you. Now, I have a handful of cases here still remaining. I just need to go back to.
I did too.
Judge, can you pull Sylvester Dante?
Yes, that was one of them.
That should have been just out on bond.
Yes. Dante Sylvester.
Yes, sir.
Are you Mr. Sylvester?
Yes, sir.
Okay, one moment. What were you telling me about this one? Dante Sylvester?
He's only here for this out on bond case. I guess he bonded on the other.
Okay. Confused. All right, I'm confused. This is a case from 2016, CF 7301, and the charge was possession of prazolam and possession of cannabis. And you're saying the defendant's currently out on bond on this case?
I just
Just a moment, sir.
He's on pretrial diversion.
Okay, so why do I have this?
Either you can take action on it or revoke it and keep him at a no bond.
Right, but I don't have the other case in front of me.
Print it out for you?
Yes.
Okay.
The new case.
have no idea what you're talking about. Thank you. Okay, has the defendant been arrested? Could someone inform me whether the defendant's been arrested on this recently signed warrant by Judge Carson on February 24th, which is case 21-568? Has that been executed? Yeah.
I-8 on the 25th at this date. He went to I-8 already. I can print this out. Bond was stated 5,000.
Okay, although it seems odd, sir, you were in the pretrial diversion
Yes, sir.
posture in case 16 CF 7301. That is terminated. You're no longer in the diversion posture. I'm revoking and holding you on a zero bond on the possession of alprazolam case from 16 CF 7301 and appointing the public defender to represent you on that case as well. And it'll need to receive a new court date. All right, thank you.
I have no bar now.
That's correct. Yes, sir.
And why is that, sir?
Because of probable cause finding that you committed an ag assault with a firearm.
But I'm innocent on that case, sir.
You what?
I'm innocent on this case. I promise to God.
Right. But it's alleged that it happened on February 19th of 2021. So the allegation is that you committed, you're presumed innocent. The allegation is you committed an ag assault with a firearm on February the 19th of 2021. Okay, that's why I took the action I did. I have about 4 affidavits here. If I could just call them up and see what the status. Cletus Motley. Cletus Motley is medical. Okay. It's an out-of-county warrant, trafficking in meth, bonds $250,000. It's out of Osceola County, so Osceola County needs to pick him up when transporting occurs.
It's restricted, Your Honor.
Restricted, okay. Taylor Olson. It's case 21MM1427.
What type of case is it, Your Honor?
It's trespass and
Misdemeanor
disturbing the
pleable?
peace. Which number?
Misdemeanor. Misdemeanor pleable. They're here.
He's mental health. She's mental health. All right, I'll appoint the public defender. Do you want to waive initial appearance?
If we could do a brief reset to see if is pretrial willing to disclose whether it's a temporary mental health issue or.
Could you put your microphone right where you're speaking?
Sorry, I'm sorry, Judge.
That's okay. I'm just now asking you. I should have a long time ago.
I'm sorry, Judge. I would just ask if PTR believes it will be a temporary mental health based on the arrest, I would ask not to waive. Whereas if PTR is inclining that it's long term, I would waive.
Okay,
I would ask the brief reset and then come tomorrow.
We'll reset Taylor Olson for tomorrow. Ronald Lockett is another one I had here.
Also mental health, Your Honor.
Mental health, I'll appoint the public defender. Mr. Counselor?
If we could reset till tomorrow and then come tomorrow, we can readdress
Okay,
it.
we'll give it one reset for tomorrow on Lockett. You going to be here tomorrow?
Yes, I am.
All right. And then Reinhard Voigt.
Mr. Voigt is also medical, Your Honor.
Okay.
Medical, I would waive.
It's also failure to appear warrant on a trespass charge. The bond will remain 0 and IA's waived, so it just needs to be set. All right. And then the last one, I think the last one, I have this Adam Phillips case here.
What type of case, Your Honor?
It's burglary and a theft case, 21 CF 2383.
He was medical, Your Honor.
Okay. I will appoint the public defender, waiving initial appearance.
I would waive.
All right, I'll keep the bonds as they were set by Judge Karsten, $3,500 on the burglary and $1,000 on the theft.
Your Honor, if I may, I got two more that I may have missed.
Okay.
Your Honor, Alfredo Soranzat.
He bonded.
Oh, thank you. That's it.
That's it? Are we done? All right, wow.
I certainly hope so.
I do think this is my record for going late. We will be in recess until tomorrow. Thanks.
Thank you, Judge. We'll be you again tomorrow.
Sorry, yep.
No,
You got a cat,
Judge, I appreciate it.
Yeah.
I appreciate you doing all the reading for me.
All right. Let's see. Oh, no. Oh. Oh, is it? Yeah. Oh, no problem. No. We'll see you tomorrow, right? All right. Have a good day. Thanks. Okay. Whew. You do this every weekend?
No.
No? Okay.
I'm just finishing a monthly.
Oh, okay. Yeah. Okay.
Yep, so it's my last.
Oh, good. Well, congratulations.
No. See you tomorrow.
Okey doke. Hopefully a little.